Today, we're unpacking Chapter 13 bankruptcy in Florida, specifically how it can be a financial lifeline for higher income individuals and asset holders facing hardship. And you're grappling with debt, this episode is just for you. Welcome to Law Unpacked, the podcast where we demystify legal topics to help you make empowered decisions. I'm attorney Sean, and today we're unpacking Chapter 13 bankruptcy in Florida. Chapter 13 isn't just for the financially destitute. It can be a strategic tool for wealthier consumers to reorganize debt while protecting homes, cars, and other valuable assets. We'll cover the latest law changes as of 2025, from new debt qualification limits to recent developments in lien stripping and cram downs. You'll also learn about Florida's unique legal landscape, our generous homestead exemption, as well as the judicial foreclosure process, and how the Chapter 13 trustees operate in different regions of the state. By the end, you should have a clear, up-to-date picture of how a Chapter 13 can help you or someone you know regain financial stability without surrendering the assets you've worked so hard for. So let's dive in. Chapter 13, bankruptcy in Florida, unpacked. Why Chapter 13 over Chapter 7 for high income earners? You might be wondering, if I earn a good living or own substantial assets, why would I consider Chapter 13 bankruptcy? Well, the truth is, Chapter 13 can offer advantages that Chapter 7 simply doesn't for higher income debtors. First, there's the eligibility factor. Chapter 7 has a means test that can bar high earners from filing if their income is above the Florida median and they have disposable income. Chapter 13, by contrast, is available to incomes with regular income regardless of the means test. Though there are debt limits as well, we'll discuss them shortly. In other words, if you make too much money to qualify for a Chapter 7, you'd be forced to repay your creditors anyways. Chapter 13 is the route to go. Asset protection is another big reason in Chapter 7. In Chapter 7, also known as a liquidation bankruptcy, a court-appointed trustee can seize and sell your non-exempt assets to pay creditors. While Florida has generous exemptions, many successful Floridians own property or valuables that exceed those limits. For example, Florida's personal property exemption is only about $1,000 for furniture, electronics, or up to $4,000 if you don't claim a homestead. Cars are only protected up to $5,000 in equity under Florida law. If you have a luxury vehicle such as an ATV or a boat, or expensive collections or a second home, these could be at risk in a Chapter 7. In a Chapter 13, by contrast, you get to keep all of your property. There's no liquidation. Instead, you propose a plan to pay creditors over time. And you only need to pay unsecured creditors at least as much as they'd get if your assets were liquidated in a Chapter 7. This is called the best interest of creditors test. For a high asset debtor, it often means you'll pay a certain amount into your plan to account for any non-exempt equity. But you won't be forced to actually surrender the asset. Imagine retaining your vacation condo or business equipment and paying off a calculated value over several years, rather than losing it outright. That's the power of a Chapter 13. Florida's homestead exemption illustrates this well. Florida allows you to exempt an unlimited amount of equity in your primary residence, your homestead, so long as the property is not larger than half an acre in a city or 160 acres in the country. Even if you own a home worth $1 million free and clear, that equity can be fully protected from creditors in bankruptcy. This is a huge benefit for Floridians. As you know, our house prices have been increasing. So those values are increasing, and this is where that benefit comes in. However, there is a catch. If you haven't owned your Florida home for at least 1,215 days, that's roughly 3 years and 4 months, before filing, federal law caps your homestead exemption around $189,000 for cases filed before April 2025 and about $214,000 after the inflation adjustment. In a Chapter 7, a newer resident with a high equity home could be forced to sell or pay the excess value above that cap to creditors. But in a Chapter 13, even if you're hit by the federal cap, you can keep your home. You simply structure your plan to pay unsecured creditors an amount equal to the non-exempt equity. For someone who moved to Florida recently with an expensive home, this can make a Chapter 13 extremely attractive as a way to comply with the law and save your home. Beyond protecting physical assets, Chapter 13 also protects your co-signers and your professional reputation. Many successful individuals have co-signed debts, perhaps a business loan co-signed with a spouse or a personal guarantee for a family member. In a Chapter 7, your discharge won't protect co-signers. Creditors will immediately chase the co-debtor for payment. Chapter 13, however, invokes the co-debtor stay, a special provision that prevents creditors from collecting from a co-signer during your bankruptcy plan. This means if you include that consumer debt in your Chapter 13 plan, the lender can't harass your spouse, your parent, or friend, whoever co-signed, as long as you're making payments in the plan. While the co-signer's liability isn't wiped out by your discharge, they're still on the hook for anything remaining, unless you pay it in full throughout your plan. This breathing room can be invaluable. It gives you time to cure the debt and potentially protect a valued relationship. High-income folks often care about honoring commitments. Chapter 13 lets you repay debts in an orderly way rather than simply walking away. This can be a point of pride or professional responsibility. Lastly, consider the stigma and control factors. Chapter 13 is often viewed as a reorganization or repayment plan, not an outright bankruptcy liquidation. For business owners, licensed professionals, or those in public positions, the perception of repaying creditors over time can be better than a straight bankruptcy wipeout. You remain in control of your assets and decide how to allocate future income to debts under court supervision rather than having a trustee sell things off. It is a proactive, take charge approach to debt relief, which appeals to many people of means who are used to being in control of their finances. Florida's unique landscape, homestead exemptions, and foreclosure. We've touched on the Florida homestead exemption, but it's worth highlighting just how protective Florida law is for homeowners. As mentioned, if you qualify as a Florida homestead, which most permanent residents do for their primary home, there's no dollar limit to the equity you can exempt. This is enshrined in the Florida Constitution and is one of the strongest homestead protections in the entire nation. It means that in Florida, bankruptcy is often not about the house. You typically won't lose your primary residence because of unsecured debts. This is a big relief for high net worth individuals for whom the home might be the most valuable asset they own. Do note, property size limits apply, and property that's too large may only get half an acre or 160 acre portion exempt. Also, as we discussed, new Florida residents need to mind the 1,215-day ownership requirement, something we at the DeVries Law Firm can help you navigate if it comes up in your case. Florida also has other exemptions that favor those with substantial assets, like 100% exemption for retirement accounts, pensions, and life insurance. These are largely protected by federal law as well. So your 401ks and IRAs, often significant for high earners, are safe in bankruptcy. Additionally, Florida has an unlimited exemption for the cash surrender value of life insurance and many annuities. These generous exemptions mean that even in Chapter 7, many wealthy filers keep a lot. But not everything is exempt, hence the need for a Chapter 13. For things like high-value vehicles, second homes, rental properties, stock portfolios, or simply high income itself, which can compel a repayment plan. Now let's talk about foreclosure. Florida is a judicial foreclosure state, which means mortgage lenders must go through the courts to foreclose on your home. This process typically takes 8 months to over a year from start to finish, as a general timeline. Why does this matter? Because it gives homeowners some time to explore solutions. And Chapter 13 is often the most powerful solution to save a home. If you have fallen behind on mortgage payments, a foreclosure lawsuit might be looming or already in process. Filing a Chapter 13 bankruptcy triggers an automatic stay that immediately halts the foreclosure proceeding. The gavel falls silent the moment your petition is filed. Even if your home is days away from a scheduled foreclosure auction, a Chapter 13 slams on the brakes as long as you file before the foreclosure sale actually occurred. Under federal law, you can file up until the auction date and still stop the sale. After the sale, it's too late. So timing is critical when filing. Once the Chapter 13 is filed and the foreclosure is paused, you now have the opportunity to cure the mortgage arrears over time. A Chapter 13 lets you take the total amount you're behind on that mortgage, plus any interest, late fees, and legal costs the lender has incurred from the foreclosure, and spread that out over a repayment plan of up to 5 years. For example, If you fell $30,000 behind on your home loan, you could propose to pay that $30,000 to the lender via your Chapter 13 plan over 60 months. That's $500 a month, while also making your normal payment going forward. The law, 11 U.S.C. subsection 1322b5, specifically allows you to cure defaults on long-term debts like mortgages within a reasonable time, which is the 3 to 5 year plan period, and then you can reinstate the loan. This means you can save your Florida home from foreclosure even if the bank refused to accept partial payments or forbearance before. As long as you can afford the planned payments, the court can approve it over the lender's objection, and the lender must accept the arrears cure and resume regular payments. Florida's judicial foreclosure process combined with the Chapter 13 give homeowners a powerful 1-2 punch, an automatic stay to stop the lawsuit, and a structured plan to fix the default. It gets better. Chapter 13 in Florida can also help with other liens on your home. Florida's booming real estate market means many homes have equity liens or second mortgages. What if you have a second mortgage or a HELOC that is completely underwater? Meaning, say your home is worth $400,000 and you owe $410,000 on the first mortgage and $50,000 on the second. In a Chapter 13, you may be able to strip off that junior lien holder. Lien stripping is a process where a wholly unsecured junior mortgage is treated as an unsecured debt and eliminated upon completion of the plan. In our example, since the $50K second is not backed by any actual equity, the first mortgage exceeds the home's value, the Chapter 13 allows you to file a motion or include plan language to declare that second mortgage as unsecured. You'd pay it the same way you treat any other unsecured credit, such as a credit card, medical bills, often pennies on the dollar.
Stay tuned for part 2.